Hello, everyone, and welcome back to Uncivil Law. As always, my name is Kurt Mueller, a licensed attorney in Texas, Virginia, and before the U.S. Supreme Court, and I hope you are having a great day. For today's story, we turn our attention to the question of birthright citizenship. Who is a citizen of the United States when they are born? This has been a controversial issue recently because, as I'm sure you will recall, Donald Trump issued an executive order that, by declaration, attempted to declare people who were born to illegal immigrants to not be citizens of the United States. The Supreme Court previously took this issue up on an injunctive relief issue, and now they're taking it up on the merits to decide the question itself, which is a bit expedited. Not completely unsurprising given the nature of the issue, but also quite fast for the Supreme Court. So this entire issue is being resolved very fast. The Supreme Court doesn't normally get involved this soon. Normally it takes 5 or 10 years for the Supreme Court to get involved, depending on the nature of the issue and depending on how issues are percolating. But obviously Trump issued the executive order earlier this year, and they're already going to decide the merits on the issue in the upcoming term. So we're going to get a decision pretty soon. So I suppose that's exciting in its own right. And we're going to try to figure out what the law is on this issue. And to do that, it would be a good time to start with the actual text of the Constitution, because that is always a good place to start. When we're trying to figure out things, let's go back to the manual, right? All right, so here is the operative language. This is from Section 1 of the 14th Amendment, which says, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state in which they reside. So, yeah, that means that I'm legally a citizen of Texas, because that's what that just said, right? I mean, I was born in the United States, so I'm a United States citizen, and I reside in Texas, so I'm a citizen of Texas. Kick ass. Now, the question is, what does it mean to be subject to the jurisdiction thereof? What exactly does that include, and what does it exclude? Now, previous cases have said that this excludes children of foreign soldiers. So in the event that we were invaded and a soldier had a child, not so much for citizenship for your child, sorry about that. It also, we know, excludes the children of ambassadors, because they're kind of not really subject to the jurisdiction of the United States due to diplomatic treaties. And also, it may exclude some other people, but the question for the moment is, does it exclude the children of illegal immigrants? Are illegal immigrants subject to this jurisdiction thereof? Now, there's a couple ways to read this, right? Because you could think of subject to the jurisdiction thereof in the same way that you think of jurisdiction, for example, for the purposes of criminal law, right? Does the United States have jurisdiction over you for the purposes of crimes? Now, this doesn't quite work, because if a foreign soldier was here committing crimes, we certainly have jurisdiction over them, but their children are not citizens. So it seems to mean something different than our ability to charge you criminally. It seems to mean something, a slightly different concept. But what exactly is that concept, and what are the borders of that concept, are, of course, the fun and tricky part for today. So we're going to read this article describing and summarizing the issue, and then we'll get into some of the briefing on it to help us understand a little bit better. So we are going to go to our good friends at SCOTUS blog, who do great work at least summarizing and providing all the wonderful links to this issue. Supreme Court agrees to hear Trump's challenge to birthright citizenship on the merits, nonetheless. So that's exciting. The Supreme Court will hear arguments early next year, so think October of this upcoming year, probably, with a decision likely. Well, let's see. If they have oral arguments in October, when are they going to come out with a decision? Yeah, that's a good question. This is such a contentious issue. It might be till June of next year, or June of the year following. So we might not get a decision until June of 2027. We'll see how it goes, though. Normally, with an October argument date, you'd be thinking maybe January or February of 2027, but it could be June. We'll see. And then, of course, whether or not they really decide it or whether or not they simply bounce the issue is a whole nother set of problems. Anyways, carrying on. The Supreme Court will hear oral arguments next year in a challenge to President, or do they mean, when they say early next year, do they mean like early 2026? Are they actually going to kind of try to squeeze it into this calendar? Yeah, what do they mean by next year? I might have interpreted that wrong. What do they mean by that? I'll get back to you on that. If they squeeze it into this term, then you're looking at a decision of June of 2026, which would be really fast. Okay, we'll see. Anyways, seeking end to birthright citizenship, the guarantee of citizenship to almost everyone born in the United States. Under the order, which has never gone into effect, people born in the United States will not automatically be entitled to citizenship if their parents are in the country, either illegally or temporarily. Yeah, so you'd have to be here in a permanent state, which suggests a green card or something akin to that, right? So we're trying to distinguish, what Trump is trying to do is distinguish people who are here on a temporary basis who still owe allegiance to their foreign country versus people who are here on a permanent basis where that is less so. So we already know from Van Ark that children of green card holders, although they weren't called green card holders at the time, but that would now be the same thing, right? People who are here on a permanent basis, green card people, we know their children are citizens. But even if they themselves are not citizens, which, but be that as it may. But what we're not sure about is temporary status. So this would include anyone on a visa, which, by the way, includes anyone here like for vacation, right? You might have an automatic visa because of the nature of your passport. You may not need to apply for a visa, right? If you're just visiting from the UK, for example, you don't necessarily need to get a visa to just visit, but you still have one. It's just automatic, right? So visa is basically just permission. And so it's like, okay, we're trying to exclude anyone who's here illegally, or even people who are here legally on a less than permanent basis. Okay, we're trying to say those people are not subject to the jurisdiction thereof within the meaning of the 14th Amendment. Okay. Let's see. The challenge argues that order conflicts with both the text of the Constitution and the court's longstanding case law. The case law is ambiguous on this point. Otherwise, we wouldn't be having the issue. The issue has never been decided. The case law that's available, to be fair, the case law that's available does suggest against Donald Trump's position, right? Because the cases that they've said basically the children of the green card people, they're citizens, although they weren't called green cards at the time because the green card hadn't been invented yet. But that's the equivalent today. The people of the green card people, they count. The children of the foreign soldiers, they don't count. The children of the ambassadors, they don't count. And that's sort of the end of the case law. So that kind of suggests the children of illegal immigrants, aren't in those categories. Now, to be fair to this issue, a lot of the reason this hasn't come up before is because the United States has gone through various periods where it's had various policies when it comes to immigration. So if you're wondering why this hasn't come up before until now, the United States had periods where it basically had open borders by policy, with the possible exclusion of particular people. For example, the Chinese citizens, as in the Van Ark case, right? That was the whole point, because of the Chinese Exclusion Act. So it's like, yes, if you come here, everyone's welcome except those Chinese people. Everyone's welcome except the Chinese people. No one's welcome. You're welcome with some certain rules, right? So our immigration policy has been varying degrees of open and not at various points. So one of the reasons it hasn't come up is because the United States had a fairly open borders policy for a fairly significant portion of its country's history. So that's one of the reasons it hasn't come up. And also, of course, the 14th Amendment itself only came up as a result of the Civil War. So you can't have any decisions before then. So that knocks off 100 years of history right away, right? Because the 14th Amendment didn't come up till after the Civil War. So you couldn't possibly have any decisions interpreting this language before then. And then even after that, it didn't come up because, well, immigration was either open or there wasn't many illegal immigrants. It just never came up. Somehow, it just never came up. So we have to decide it for the first time now. But okay, we're going to do that. The announcement came in a brief list of orders, which it does. The Supreme Court will list another list of orders, including cases from its conference, as it does. The United States is one of roughly 30 countries, including Canada and Mexico, that offers automatic citizenship to nearly everyone born there. Yeah, birthright citizenship is not that common, and I also dispute this characterization of our friends when it comes to their birthright citizenship. The United States version of this is extremely rare. Saying 30 countries have it is, I think, a gross mischaracterization of the nature of their laws, but we'll press past that point. Birthright citizenship was added to the Constitution in 1868. That'd be that post-Civil War I mentioned, when the 14th Amendment was adopted following the Civil War. The section of the amendment known as the Citizenship Clause, which we just read, provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state in which they reside. My Texas citizenship is looking very good to me. The amendment was intended to overrule one of the Supreme Court's most notorious decisions of Dred Scott. Yeah. In holding that a black person whose ancestors were brought to the United States enslaved were not entitled to any protection from the federal courts because they were not a U.S. citizen. Yeah, Dred Scott was not one of the better decisions of the United States. It's a decision that, not great. Let's just move on. In a related case in 1898, the Supreme Court ruled in favor of Wong Kim Ark, who was born in California to parents of Chinese descent. Yeah, as I mentioned earlier in our description, this was because of the Chinese Exclusion Act, but his parents were what we would call today green card, although in 1898 the green card didn't exist, but that's the equivalent today. So, yeah, it was a whole mess. By a vote of 6-2, the court rejected the government's argument that Wong Kim Ark was not a U.S. citizen, with Justice Horace Grace explaining that the 14th Amendment, although enacted to establish citizenship of black people, affirms the ancient and fundamental rule of citizenship by birth within the territory. And then, this is critical language, so pay attention. In the allegiance, and under the protection of the country, including all children here born of resident aliens. That's the critical language when you're reading this decision. That's what we're trying to distinguish, right? So this is why we think, or a lot of people think, this case is different than the precedent. There's these two clauses in here, right? First of all, is in the allegiance. That was part of the decision from Wong Kim Ark, right? So Wong Kim's Ark, despite their Chinese citizenship, were in this green card status, although the green card didn't exist yet, but close enough for our purposes. We'll call it a green card, okay? So they're in this green card status, and therefore they have allegiance to the United States because they're in this status that today we'd call a green card. So they have allegiance, like they've pledged allegiance, not in the I go to school every day and plead allegiance sense, but in the please I'd like to come to your country and be one of your residents. I'd really like to be here, and I promise my fidelity and my honor, and I will defend the United States, and all that stuff that basically is part of the citizenship oath. It's also kind of part of the green card thing, even in 1898, even though we didn't have the green card yet. But same idea, right? So these people have pledged allegiance in a very formal legal sense. So that's a thing. And then, of course, this language, born of resident aliens, is the language from Kim Van Ark, right? What does it mean to be a resident alien? Well, today, again, we call this a green card, right? What is not a resident alien? Well, anyone here on a travel visa is not a resident alien. That doesn't make any sense. When people from the UK or France or Spain or Mexico or Canada or many countries in the world come to visit the United States, as they do, to visit Disney World or New York or Las Vegas, as they do. Are they residents here? That's ridiculous, right? They're decidedly not residents. They're They are here on a temporary permission. I think it's 90 days, but don't quote me. It doesn't really matter. But right, their permission to be here for the travel, maybe it's 180 days. It doesn't really matter what it is. It doesn't matter if it's 30 days or 90 days or 180 days. I don't know what it is. It doesn't matter. Basically, they are on a clock. And it's like, yeah, you're not residents. You're here for 30 days or 90 days or 180 days, and then get the fuck out. You can come back later, but you have to leave. Then you can come back. Or ask for extended permission or something. Right? So the people that are visiting here on their travel visas are not residents. That's ridiculous. Even if somehow they bought a house, even if they were squatters for the purposes of some state law, right? They moved into some property somewhere more than 30 days and they're squatting. It's like, this is my house now. I live here. The United States is like, no, you don't. You know, the state, whether or not that's your property for the purposes of the state law of New York or California, we don't know. Maybe it's your property for the purposes of state law because, well, the state determines whether it's your property for the purposes of state law. So is it your property for the purposes of state law? Maybe, you know, go to state court. They can figure it out. But you can't stay here. So you got to go. This is my house now. Well, be that as it may, it's located in the United States. Get the fuck out. So that's the whole Kim Van Ark thing. So of all that, right? So that is the language that they're trying to distinguish. Right? They are not, the illegal immigrants nor the people on the travel visa have pledged allegiance, even if they want to, like, in their own hearts. Right? I don't know if any illegal immigrants, when they come here, secretly or maybe even publicly say, I want to be an American. But, you know, we have to accept your allegiance, right? This is not a one-way street, right? Kind of like pleading your allegiance to the king. We have a king. It's called the United States government collectively, right? We have a sovereign. We call it sovereignty instead of a king, right? We have a sovereign. And so I'll use that language because it's less charged. We have a sovereign, right? The sovereignty of the United States. And so the sovereign has to accept your allegiance. So you can pledge your allegiance, but the sovereign has to accept your allegiance. And if not, get the fuck out. So I don't know if any illegal immigrants are trying to pledge their allegiance, but the sovereign ain't having it. So the sovereign doesn't want your allegiance. Get the fuck out. So yeah, that's definitely a thing that's happening. In a dissent, Chief Justice Merville Furler argued that Wong Kim Ark was not a U.S. citizen because he was not completely subject to the jurisdiction of the United States as a Chinese citizen. His parents had a duty to the Emperor of China, and federal law barred them from being U.S. citizens because of that whole Chinese Exclusion Act thing I mentioned earlier. Yeah, the United States has gone through various periods. Everyone's welcome. Everyone's welcome except for those dirty Chinese. You know, everyone's welcome except for the Irish for some reason. Everyone's welcome except for the Italians. You know, we have had some but you know, that's our right as a country. We can accept people or not, as is our pleasure. It's not illegal. It's just, I guess, a little bit weird, but it's not illegal because the United States as a sovereign has the right to control its borders, absolutely. Now, it can choose not to do that, right? For example, all those wonderful countries in Europe that are part of, what's it called, the Schengen Agreement, I can never pronounce properly, right? There's right of free travel across all those countries. So it's like, yes, you can travel our borders. You don't need a passport. But that's because they've made that decision by being part of the Schengen Agreement. It's an agreement. You know what one of those countries could do? How about not so much? How about we don't want to be part of this agreement anymore? Screw you. And we're going to throw up a fence. They could, because it's an agreement. They're a sovereign country. They can do what they like. So can the United States have totally open borders? You bet your ass. Can the United States close its borders completely? We will not allow any immigrants nor any visitors. You cannot come into our country. Literally, no one is allowed unless you're a U.S. citizen, maybe a green card holder. Get the fuck out. Can we do that? Yes. Can we, by statute, mind you, because the Chinese Exclusion Act was a statute passed by Congress, so that matters. Can Congress declare no people from that dirty, dirty country, China? You bet your ass they can, right? What are you going to argue? Equal protection? Equal protection only protects us. It's our constitutional guarantee. It's like it violates the Constitution's equal protection. You mean our Constitution, the one we wrote for us? Yeah, get the fuck out, right? So Congress can do pretty much anything in this domain. And they're like, not so much with the Chinese people. They can't be citizens. And the US Supreme Court's like, well, they're green card holders or the equivalent. So close enough, for their children. Maybe you can prevent Kim Wong Ark's parents from becoming citizens. Maybe you can do that, but not so much their children. So that was the decision. And where we go. Fine. All right, pressing on. Trump executive order on birthright citizenship has spurned multiple lawsuits. You don't say. In Seattle, one federal judge temporarily barred the Trump administration from enforcing the order, while a federal judge in Maryland separately blocked the Trump administration from enforcing the order while challenged by immigrants' rights groups, and several individual pregnant women moved forward. Exciting. The Trump administration came to the United States in spring. Would it be retroactive? Probably not. Probably not, because something reliance interests. So it probably would not be retroactive. It probably would only be something going forward. Because the United States Supreme Court doesn't want to create more problems for itself than it has to. So it'll probably say something reliance interests so that it's not retroactive. Probably. Yeah, pressing on. Okay. Do legal immigrants have an oath of allegiance? For green card, close enough, yes. Yeah, retroactive would also mean it's work. Yeah, they don't want to, that too. The Supreme Court also doesn't want to try to untie all that, right? If they made it retroactive, then how do we deal with children of children and so forth? And, because you're going all the way back to 1868, because that would be when the constitutional text was passed, right? So whatever the Constitution says on this, it said it since 1868. So if you made it retroactive, now you suddenly have to untangle children of children of children of children, probably, since 1860. That's no one wants a piece of that. And you have to deal with mixed and marrying citizens and no one has time for that bullshit. So yeah, probably just like starting January 1st of next year. That sounds like a good date. Let's just do January 1st of the following year. And that sounds like a good rule. Yeah, that sounds right. Yep, that sounds exactly like that's what's going to happen. Yep, 100%. The Trump administration came to the Supreme Court in spring. But Solicitor General did not ask the justices to weigh in on the legality of the president's orders, right? Because they were just trying to do the universal injunction thing, which was a big decision unto itself, incidentally. The universal injunction thing, depending on how you look at it, is as large in scope as the underlying merits decision. It was a big deal. It was a big deal for the law geeks, at least. It was a very big deal. So, yeah, initially only the universal injunction thing, and then they said not so much with the universal injunctions anymore. We're still trying to figure that out a little bit, but yeah. Anyways, instead the issue was on the issue of the universal, national, global, whatever injunctions. They go by many names. Orders that federal district courts that bar them from enforcing a law or policy anywhere in the court. Yeah, should one of 94 random districts be able to create an injunction that bars the government everywhere? And they're like, no, not so much. Yeah. After the United States issues its ruling, holding district courts generally cannot issue such orders, with maybe the exclusion of class action stuff, which we're still trying to work our way through. We'll get back to you on that. Challenges continued on the merits. In Barbara versus Trump, a federal district judge in New Hampshire issued a preliminary injunction that barred the Trump administration from enforcing the executive order against classes of babies born on or after February the 20th of 2025 who are or would be denied citizenship by the order. And Trump v. which is probably just as well, right? I mean, yeah, just the class. Yeah, we don't want to go to all. Yeah, at least since the order was passed. Yeah, maybe the Supreme Court will go back to when the order was written, because they don't have to unwind too much to go back to when the order was written. Yeah, they're not. Maybe they'll do that. And Trump v. Washington, a divided panel of the Court of Appeals for Ninth Circuit ruled the executive order is invalid because it contradicts the plain language of the 14th Amendment citizenship, which of course says all persons born in the United States and subject to the jurisdiction thereof. And then, of course, what does subject to the jurisdiction thereof mean is the eternal question. So all that good stuff. An oath makes you an American. If the United States accepts it, yes, it does. That's the deal. Well, part of it, yeah, that's the last step in the process. Yeah, the oath is the thing, the oath is the last step. So yes, the oath very literally makes you an American. But the critical part is because the sovereign accepts the oath. That's the other part of the equation, right? We accept your pledge of fealty. And then yes, you're a citizen. That's how that works. That's how that's always worked. Yeah, you pledge, are you guys confused by this? It's like, yes, the king or the sovereign, as the case may be, you know, you used to go to the king and pledge your loyalty and fealty and all that bullshit. And the king would say yay or nay. And if he said yay, then, you know, you're one of his subjects / lords / whatever. And, you know, blah, 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 bombs. And now you're a citizen of, you know, England or Spain or Portugal or, you know, whoever it is you're pledging your allegiance to. That's exactly how that's worked. That's exactly how it's always worked. Yes, the oath makes you a citizen because the sovereign accepts it. No exception here. Yeah, that's exactly how that works. 100% correct. You got it. Well, what about if you break your oath? Well, it depends. If you lied about the oath in the first place, your citizenship might be able to be revoked. Excuse me one second. If you lied about, well, what would happen in antiquity? Right? Answer this question just from antiquity. Okay. What would happen if you pledge your allegiance to the sovereign, let's say the King of England, you know, maybe before Magna Carta or something, so we give this, or the King of Saudi Arabia, because they're still an absolute monarchy, right? What happens if you pledge your allegiance to the King of Saudi Arabia and, you know, then at some later point, you don't have allegiance to the King of Saudi Arabia? How does that usually work out for you? Not great. Yeah, just there you go. That's the answer to your question. Okay. The Trump, excuse me. And likewise in the United States, although we're less cruel and barbaric about it, but we will, you know, put your ass in jail. The Trump administration came to the Supreme Court at the end of September asking justices to take up both cases. In petition for review, it argued the 14th Amendment Citizenship Clause was adopted to confer citizenship on the newly freed slave and their children, not the children of aliens temporarily visiting, which is, you know, not the worst argument I've ever had. Has there been a ruling? Has there been a ruling on the question of birthright citizenship? Yes. The Supreme Court has ruled on the issue. That's why you're getting notification from every news site in the nation right now. It's headline news, and all the news can talk about because the Supreme Court's actually made a decision. Do you people think about these things before you ask these questions or not? I'm just raw curious. Oh, they did? I haven't seen the news yet. That's the point, Tony. Of course you haven't seen the news yet because it hasn't happened. Is the sarcasm not obvious? Even Tony can't pick up the sarcasm. Yes, the Supreme Court's ruled on it, which is why it's being covered by every news station. But it's not being covered by every news station. Right, so what conclusion can you draw, Tony? I'm dying over here. I'm dying. You don't get sarcasm? That's rough. The challengers in lower courts cannot rely on the court's 1898 decision. If you don't speak sarcasm, man, you are on the wrong channel. Yeah, if you don't do sarcasm, this may not be the channel for you. I speak fluent sarcasm and snark. So you're going to have a rough time here, man. Opposing review, the challengers countered that Supreme Court has already decided more than a century ago in Wong Kim Ark what the Citizenship Clause means. But in any event, they wrote in 1940 and again in 52, Congress enacted federal law that essentially codified Citizenship Clause and did so with Wong Kim Ark in mind. So it violates federal law. But does it though? Did it? I don't know, man. On Wednesday afternoon, the court granted the Trump administration petition for review in the Barbara case. The justices apparently did not act on the administration petition for review in Trump v. Washington. If it seems as likely the court did not take up the case, it will presumably remain on hold until the court issues a decision in the New Hampshire case. The court also indicates that it intends to fast track the case, which means they will hear arguments in the spring. So they're going to try to hear it this year. They're going to try to squeeze it into this calendar year, this term. So they're going to try to have the decision. They're going to try to have argument, in March? And with a decision in June? Woof. All right, let's read a little bit more about this case. Barbara. This is District of New Hampshire? Did they fast track it out of the district court? I guess they must have. Okay, I guess they fast tracked it out of the district court. Okay, that's notable. What is this Ninth Circuit thing too? Trump v. Washington. So they've taken two cases? Is that what they're doing? Oh, they haven't decided this one out of Washington yet. Okay, so the only case they've taken right now is out of the district court. Interesting. That's interesting. They took it out, straight out of the district court decision. Huh, okay. I wonder why they did that. Okay, interesting. The Roberts Courts doesn't have the balls to revoke birthright citizenship. Yeah, I mean, the smart money is probably against them. The smart money is for them interpreting the 14th Amendment against the administration. Obviously, you need at least 5 votes. And those are going to be tricky to get at best. So yeah, the smart money is on the administration losing this issue. Or in the alternative, the Supreme Court bouncing the issue, which then why did they grant expedited review in the first place? But it's like, yeah, are they going to grant expedited review only to only to turn around and punt it again? I guess they could, but what would be the point? Yeah, so let's read some of the petitions. Yeah. Amy Coney Barrett's vote is by no means secured. Roberts' vote is by no means secured. Kavanaugh probably decides with the administration. Thomas does. Alito probably does. You're not going to get any of the liberal justices for sure. Yeah, you're going to have to get Roberts and Coney Barrett and possibly even Alito. Gorsuch is an interesting one too, on how that pans out. Yeah, you're going to have a tough time getting your 5 votes. All right, let's read the merit briefs on this for a while. See what they're trying to do here. Oh, they don't have merit briefs yet. Obviously, it's too early. Fair enough. Okay, let's just read the petition for certiorari. Yeah, cert before judgment filed. So they did a petition for cert before the before the Court of Appeals, right? So when they say before judgment filed, what they mean is before the judgment of the Court of Appeals. So they're skipping straight from the district court to the Supreme Court, which is something you can do, and has been something that's been happening more recently. This used to be uber rare. This used to basically never happen. In the Trump administration era, it's been happening more. So it went from uber rare to actually fairly frequent, to be honest. So it's definitely changed as a procedural mechanism, to be sure. All right, let's read the petition for cert, or at least skim it. Okay. Let's see. Let's see what they say on the issue of the. I want to skip to the part where they get to the issue of the interpretation of the clause. Let's see. 14th Amendment with primary allegiance, Citizenship Clause, INA. The question warrants the court should grant review in both Washington and Barbara. Okay, so we can skip to, it looks like page 15. So read pages 15 to 28 of this thing on the primary issue. Okay, the 14th Amendment grants citizenship to children of those with primary allegiance to the United States, such as citizens and lawful permanent residents. For several reasons, the Citizenship Clause does not grant citizenship automatically to everyone born in the United States and subject to U.S. law, but only those born with primary allegiance to the United States. First, the plain text of the clause requires more than birth on the U.S. soil alone. The clause provides that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. The plain language of the clause refers to two conditions. A child must be born in the United States and subject to the jurisdiction thereof. If jurisdiction meant merely regulatory jurisdiction, the second criteria would add nothing to the first, because the jurisdiction of the nation within its own territory is necessarily exclusive and absolute. Yeah, so it's got to mean something, right? Because if it just simply meant subject matter jurisdiction, right, if that's all it meant, then being born in the United States would necessarily get you there. Because the United States, like every country, is sovereign and has absolute control within its borders. That's one of the benefits of being sovereign. So, it can do kind of anything. So if it meant merely the sovereign owns your ass, that would be everybody. And so it must mean something less than that. Respondents' interpretation would thus render the second criteria meaningless. But see Marbury versus Madison. It cannot be presumed that any clause is without effect. Accordingly, in the first case interpreting Citizenship Clause, well, I don't know if that's necessarily true, but either way, the court stated, it's going back in time, so that makes sense. The court stated the phrase was subject to the jurisdiction thereof was intended to exclude from its operation citizens or subjects of foreign states born within the United States. Well, that seems like that might be helpful language. And we're going to the slaughterhouse cases? That's hilarious. Soon thereafter, the court clarified that subject to the jurisdiction thereof did not mean mere regulatory jurisdiction, but political jurisdiction. That is, lasting ties to create allegiance. The evident meaning of the last words is not merely subject in some respect or degree to jurisdiction in the United States, but completely subject to political jurisdiction, owing them direct and immediate allegiance. Yeah, I tend to think that this is true. It makes sense. It's like the sovereign has to, in some sense, accept your pledge of fealty, right? So that makes sense. Reinforcing that holding, Elk reiterated that being in geographical sense born in the United States does not suffice for citizenship under the clause. The court subsequently explained that those covered by the clause included children of U.S. citizens and aliens who have permanent domicile and resident in the United States, which we discussed before from Wong Kim Ark. The clause's enactment history, too, refutes the respondents' theory. The same Congress that proposed the 14th Amendment enacted the Civil Rights Act just a few months before, and the clause was designed to adopt the same meaning as the act. The Civil Rights Act provided that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared citizens of the United States. Yeah, we already did that too, by the way. The U.S. Supreme Court, by the way, also decided that Native Americans are not citizens by the 14th Amendment. So that we did that too. Yeah, the Congress later passed a statute making Indians, Native Americans, citizens of the United States. But the initial interpretation was that Native Americans and their children were not citizens of the United States. The Supreme Court decided that too. So there's that. So if the children of Native Americans don't qualify as citizens, and they've been here for a couple thousand years, The act, like the clause, contemplated two criteria for birthright citizenship, both birth and political allegiance. Birth on the U.S. soil, born in the United States, and having primary allegiance to the United States. Substantial authority in decades preceding the clause's adoption establishes that domicile, which is lawful permanent residence, with intent to remain, establishes the relevant political allegiance. So we need domicile. Yeah. As Justice Story wrote, a person owes allegiance to the country in which he's domiciled. Such individual places himself out of the protection of his former country and becomes a member of the new society, at least as a permanent inhabitant, as a kind of citizen of an inferior order, but nevertheless united and subject for society. Yeah, I mean, fair enough. It's like, yeah. When you try to become a permanent resident of one country, your other country is probably not going to like you as much anymore. You kind of have to trade the one for the other. That's sort of how that's supposed to work. As a result, once someone has fixed his abode in another country, he becomes a member of that society, at least as a perpetual inhabitant, and his children will be a member of it also. That understanding, linking domicile with political jurisdiction, prevailed in this court's cases in decades following the Act clause's enhancement. I like the way this is written very much. This is very, very good. Yeah, this is very, very clean, and I like it. The court held that foreigners who become domiciled in a country other than their own acquire rights and must discharge duties in many respects as the same possessed by and imposed on the citizens of that country. As the court explained, aliens residing in a country with the intent of making a permanent place of abode acquire, in one sense, a domicile there, and while they're permitted by that nation to retain such a residence and domicile, are subject to its laws and may invoke its protections against other nations. The debate on both the Civil Rights Act and the 14th Amendment reflected the same understanding. Senator Lyndon Turnbull, the Act's principal sponsor in the Senate, explained its purpose was to make citizens of everyone born in the United States who owed allegiance to the United States. In a letter to President Johnson, he explained that the Act would make citizens of all persons born of parents domiciled in the United States, except untaxed Indians, the poor Native Americans. During debates on the amendment, Senator Trumbull explained, what do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anyone else. It cannot be said of any Indian who owns allegiance, partial allegiance if you please, to some other government that he is subject to the jurisdiction of the United States. Senator Trumbull went on to equate being subject to our jurisdiction with owing allegiance solely to the United States. Well, at least primarily, one would assume, but yes. Other members of Congress shared that understanding. In debates over the Civil Rights Act, Representative James Wilson explained that a person born in the United States is a natural-born citizen, but he recognized exceptions for children born on our soil to temporary sojourners. I do like that word, sojourner. It's a great word. Or representatives of foreign governments. In debates over the amendment, Senator Benjamin Wade, who proposed a version of the clause that omitted subject to the jurisdiction thereof, agreed that jurisdiction language reflected the pre-existing rule. And always good, by the way, when you the language is based on something that pre-existed, right? It's like, we're not trying to create anything new. We're trying to reflect what's already true or was true in common law or something else. It's like, This is a pre-existing concept that we're simply ratifying and turning into constitutional language. So that's true for a lot of the Constitution. It's true for the First Amendment. It's true for the Second Amendment. It's true for a lot of the amendments, right? It's like, this is a concept that we are pre-existing and now making part of the Constitution. So to some degree, that's true for a lot of the amendments. Any event, in debates over the amendment, Senator Benjamin Wade, who proposed a version of the clause that amends subject to the jurisdiction thereof, agreed that jurisdiction reflected in the pre-existing rule that persons may be born in the United States and not be citizens, which will exclude a person who's born here of parents from abroad temporarily in the country. And Senator Renvry Johnson, how are you supposed to pronounce this word? Revdy? And Senator Revdy Johnson agreed that all this amendment provides is that persons born in the United States and not subject to some foreign power shall be considered as citizens. So this language, of course, is of some utility because it helps to reflect at least the ideas this language might mean, right? You're using congressional history, but you're also trying to understand like what they are talking about. So this is helpful language, in trying to understand what these people are talking about. This is more of like an originalist philosophy. This is going to like, what's the history of this thing? How did this come about? What is the origin of this language? And so this is, trying to reflect that idea. So, okay. Given its original meaning in history, the clause does not extend citizenship to children of transient visitors or illegal aliens. First, during debates on the adoption of the 14th Amendment, it was not controversial the clause would exclude children of temporary visitors. As noted above, Representative James Wilson recognized that children born on our soil to temporary sojourners would not be citizens, and Senator Benjamin Wade acknowledged that a person born here of parents from abroad temporarily in the country would not be covered. That understanding reflected the original meaning of subject of jurisdiction thereof. Transient visitors are not included because they've not established sufficient ties to the United States to place themselves in a relationship of allegiance and protection. My eyes are glassy? I don't think so. I'm not seeing any glassiness. It look okay to me, but all right. As Justice Story wrote in 1834, a reasonable qualification of the rule that birthright citizenship is they should not apply to children of parents who were interring in this country or abiding there for temporary purpose such as health or occasional businesses. Because temporary present aliens have not established permanent domicile or residence in the United States, they have not accepted those rights and duties similar to citizens. In fact, under the immigration laws, many classes of temporary present aliens, including tourists, students, and temporary workers, are admitted only to express requirement that they have residence in a foreign country, which they have no intention of abandoning. Such aliens, therefore, lack the legal capacity to establish domicile in the United States. Fair enough, right? Domicile is different than residence. Domicile is this place of your one, I don't know how you would describe it. Basically the one true home, the place to which you intend to return, the place to which, is your true home. It's hard to describe the concept really in law, but there's a difference between residence and domicile because you can have like the easiest example of this is someone who has multiple homes, right? So a person who has multiple homes and they live, let's say they have 12 homes in 12 different states, okay? And this person lives 1 month in each home. They have a January home, a February home, a March home, and so forth and so on, right? So they reside in each of these homes for 1 month of the year as they do, but they can only have one domicile. The domicile is the place in which they presumably register to vote. It's the place presumably that they have their driver's license. It's their one true home, right? And domicile, once established, can only be changed by intent. So you initially have domicile in the place that you're born, if you're a US citizen. So like that, and then you can change that. And it's like you have to, it's not just because I live there. You could theoretically live, if you have domicile in New York and then you move out of New York and you live somewhere else for even an extended period of time, you can still have domicile in New York. This is incidentally like why people who are US citizens who live overseas can still vote in their state that they left, right? It's like, I still have domicile in the state that I haven't been to in 20 years. And so it gets complicated, but all that stuff. Thus, the New Jersey Supreme Court explained that the citizenship clause excludes those born in this country of foreign parents who are temporarily traveling. New Jersey Supreme Court, 1895. Similar before the 14th Amendment, the Supreme Court of Texas found that the exclusion from birthright citizenship was fully sanctioned law and too rational and well settled to be any question, 1849. And when a New York court similarly explained that individual who's traveling or sojourning in another country, he continues under the obligation of allegiance to his home country, and his children accordingly fall within an exception to the rule that makes the birthright a place of citizenship. One moment, please. Great. All right, let's see. I need to figure out how to get that hyper chat feature back into OBS again so I can more easily ignore non-member chats. It used to be I had it built into OBS, but now for some reason I somehow got rid of it. So I need to figure out how to have that again so I can just filter out all the non-member chats and make my life easier. But for the moment, I'll just go to my YouTube backend and do it that way so I can exclude all the non-member chats so I won't be distracted anymore, and that would be nice. Great. Let's press on. Let's see. Even after the amendment's ratification, commentators widely agreed. The word subject to the jurisdiction thereof excludes children of foreigners transient within the United States. Children born in the United States to foreigners here on transit resident are not citizens because by the law of nations, they were not at the time of their birth subject to jurisdiction. So this is all helpful language to understanding what the original language was meant to include or exclude, right? What people were talking about, ratification discussions, other commentaries, right? We're all looking for things that were happening at the time, not to understand necessarily the intent behind it, but to understand the history behind it, how the language came to be, what they were talking about, and so forth and so on. As once stated, a fortiori, the children of foreigners in transit resident are not citizens, their fathers being subject to jurisdiction less completely than Indians. Contemporaneous executive branch authorities enforced that conclusion. In 1885, Secretary of State Frederick, wow, this is a hell of a name, Frederick T. Frelinghuysen. Frederick Frelinghuysen denied a passport to an applicant who was born of Saxon subjects, which presume, what do they mean, German or English when they say Saxon? Yeah, which Saxon? OG Saxon or new improved Saxon? Temporarily in the United States because the applicant was subject to a foreign power. And the fact of birth under circumstances implying alien subjugation establishes no right of citizenship. Frelinghuysen? Okay. Frelinghuysen. Nice. Later the same year, Senator Frelinghuysen, successor Thomas F. Bayard, denied a passport to an applicant in the state of Ohio to a German subject domiciled in Germany, explained the applicant was on his birth certificate subject to a foreign power and not subject to the jurisdiction of the United States. And the official regulations governing the administration of the Chinese Exclusion Act exempted any person who had been born in the United States, a person at the time at birth, having a permanent domicile and residence in the United States. So even the Chinese Exclusion Act had an exception for the permanent residence, what we would now call a green card, as I sort of said earlier. Likewise, illegal aliens lack the primary allegiance in the United States required for birthright citizenship. I find this language pretty convincing. I don't know if the Supreme Court's going to go this way. And if they are going to go this way, they're definitely not going to make it retroactive because God help us all, right? Yeah. God help us all. They'll probably say, effective as of January 1st of 2027 or something. Congress may preclude a class of aliens from establishing domicile in the United States. Yes, because exactly so. This is, again, the ability for us to control our own borders and control our own country. So we can prevent you from having a domicile here. Domicile is a legal concept, and it's like you can't have it here because, you were born in France or something. It's like, but I really like the United States. I'm like, that's great, but not so much. No domicile for you, but I live here all the time. Yeah, that's unfortunate for you. Back to France you go, you Frenchie. Provisions of international laws that bar individuals from relinquishing their former domiciles leave them without legal capacity to establish domicile in the United States. Preach. A person whose very presence in the country unlawfully lacks the legal capacity to establish domicile. I like all these citations, all this history. This is great. I'm here for it. That conclusion draws further support from the principle that no wrongdoer should profit from his own wrong. No man may take advantage of his own wrong. Nice. The lower court's contrary decisions rest largely on an overreading of Wong Kim Ark. They sure do. It's not like it's hideously out of place. I mean, to be fair, the precedent doesn't answer the questions explicitly either way, which is why we're having the debate. So when you read the decisions that are there, they seem to be carving out very narrow groups, not so much for the Indians. I don't know how narrow that is, but whatever. Not so much for the Indians, not so much for the foreign soldiers, not so much for the ambassadors, right? If you would think that if it was not so much for the illegal aliens that, it would have come up, but for reasons I just said, or reasons I was talking about, not so much because, open borders was a thing, depending on how you define it, open borders was a thing well into the 20th century. Basically anyone who comes here is welcome here. Was a thing kind of well into the early 20th century. Modern immigration law didn't really start till, depends on your definitions, but I mean, post-World War I, again, it depends on your definitions a little bit, but it's a relatively recent phenomena. And even then, like illegal immigration wasn't really too much of a concern until relatively recently. The number of illegal immigrants, illegal immigration has only really been a problem in varying degrees since, I don't know, what do you want to say, the 90s? And obviously becoming more accelerated with every passing year since then. So 1990s, maybe is the start of the modern problem and didn't really kick in until, I don't know, take your pick of when it kicked in. But in any event, it's relatively recent. So it just hasn't been a thing. And now it's a thing. Okay, anyways. In Wong Kim Ark, this court held that children of lawful permanent residents domiciled in the United States, as well as those of citizens, fall within the clause. Wong Kim Ark left no doubt that a resident alien's domicile, a word the opinion used 22 times, was central to its holding. Yeah, it was not just a throwaway. It was a key aspect of the decision. The court framed the question presented and holding its terms. At the outset, the opinion stated that a question presented by the record is whether citizenship extends to a child born in the United States of aliens who at the time of birth are subjects to the Emperor of China, but have permanent domicile and residence in the United States. Right? So this again is kind of like a green card, right? Green card holders don't necessarily give up their citizenship to the foreign country like a citizen does. So they're kind of halfway. It's kind of citizenship light. But, it is what it is by statute. We've created this statute. We've created this category of lawful permanent residence. Like, you're not a citizen, but you're kind of some lesser class of thing. You're allowed to stay forever. And you can still have allegiance to your foreign country and blah, blah, blah. But we are granting you domicile because it's our law, right? It's not that complicated in the end. Like, it's our law. We determine who has domicile. We can determine it on any basis we want because we have sovereignty within our own borders, like any country does. So your allegiance or lack thereof to a foreign state is only interesting insofar as we make it interesting. We could theoretically have a citizenship oath that does not require you to renounce citizenship to the foreign government. We could do that. I'm not sure it'd be wise, but we could, right? We could say, you know what? You want to be a citizen of the United States? That's great. You're also loyal to, the King of Spain. Cool. We love dual loyalty. Dual loyalty is our great thing. If we ever go to war with Spain, we understand that you may have to make a decision and may go to war with us, but that's okay with us. I'm not sure why we're passing these policies, but we can. We are allowed to be stupid, unfortunately. It's in the nature of sovereignty. We're allowed to make choices, and then we have to be responsible for those choices, even if the choices are stupid. Right? But it's our call. It's our call to be stupid. Only we can make ourselves stupid. You can't force us into the stupid. But we don't need your help to be stupid. We're Americans. We can do stupid on our own. We know the stupid. We live in the stupid. We don't need your help. So we could do that. At the outset, the opinion stated that the question presented by the record, we read that part. At the end of section 5 of the opinion, summarizing the lengthy review of historical and legal sources, the court announced the governing rule. The amendment includes children born within the territory of the United States and all other persons of whatever race and color domiciled in the United States. And domicile is one of those key words. The people that went to law school should recognize the word domicile. Probably not so much if you didn't go to law school. You probably have never contemplated the word domicile. But that's okay, yeah, because it's a very interesting concept and somewhat hard to clearly define. It's a little confusing, but yeah, it can be fun sometimes. You can only have one of them, at least as far as the United States is concerned, I suppose. Anyways, pressing on. Then and incidentally, by the way, domicile may or may not mean that in other countries because I can't even begin to be bothered by what domicile does or does not mean, like in France. I don't know if domicile has the same meaning. So if France says you're domiciled there, I don't know what France considers that to mean. I don't know if that means that's where you live. I don't know what it means in France. Can't speak to that. I'm only a US lawyer. I mean, I can only do so much, man. Right? But I know what it means here, mostly. Then at the opinion's conclusion, the court stated that it determined a single question, namely, whether question born in the United States, child born in the United States, of parents of Chinese descent who at the time of birth are subjects to the Emperor of China, but have a permanent resident, become citizens. And then they're like, yes. Notwithstanding his parents apparently can never become US citizens. He has this green card status. Again, we haven't invented the concept of the green card yet, but that would be the modern equivalent. He has a green card. And so, close enough. In fact, Wong Kim Ark implies that illegal aliens are excluded from citizenship. It states that aliens are entitled to protection and owe allegiance to the United States so long as they're permitted by the United States to reside here. There is enough language for the Supreme Court to decide this in the Trump administration favor. Yeah, there's definitely enough language from the case law and enough language from the founding era and so forth. There is enough language to go this way. I hope the Supreme Court will go this way. I'm doubtful they will go this way. Are you going to get 5 votes for this? Are you really going to get Amy Coney Barrett and Roberts to go along with this plan, let alone necessarily Gorsuch, and even Alito's a bit of a question mark to some degree. Thomas and Kavanaugh are probably your safest votes. Alito is pretty safe. Gorsuch is a bit of a question mark. And Roberts and Amy Coney Barrett are really question marks. So I don't, and Gore and Roberts in particular. Roberts doesn't like to make decisions that are like this. He wants to find some middle ground to make everyone happy. So I have my doubts they're going to go this hard. So if you're taking bets, I think you have to bet against. Does Polymarket have a bet on this thing? I'm curious, out of raw curiosity. Let's see if Polymarket has a bet on this. Because they're pretty good about being a reasonable prediction. The wisdom of the crowds with, let's see if we search Polymarket for... I don't think they have it. How does Polymarket not have a bet on this? Can I create a bet on this? If not, I should. I should absolutely create a bet on this. Maybe I'll create one. Because this needs a bet. I think the safe money is betting against. I don't know, man. All right. Attempts to read Wong Kim Ark are more broadly than its holding are mistaken. First, those attempts extend beyond the holding of the case. As Wong Kim Ark itself warned, general expressions in every opinion are to be taken in connection with the case which those expressions are used. If they go beyond the case, they may be respected, but not outright to control a judgment in subsequent suit where the very point is presented for decision. Moreover, the emphasis on domicile and permanent residence was central to Wong Kim Ark. For example, the court quoted an opinion which Justice Story, Hala, recognized that children, even of aliens born in this country, while their parents are resident there, under the protection of government, are subject by birth. Based. The court quoted with approval the New Jersey Supreme Court's observation. The 14th Amendment codifies the general rule. When parents are domiciled here, birth establishes the right to citizenship. Also, by the way, incidentally, for whatever it's worth, because it's worth noting, citizenship can also be granted by statute or by Congress, because Congress has the right to control the uniform rules of immigration. It's right in the thing. So even assuming that the Supreme Court grants a decision in the administration favor, if there's ever enough votes to do so, Congress could grant citizenship, although not necessarily birthright citizenship, but what's the difference, really, right? So they could grant citizenship to everyone who, well, basically on any terms they want, because it's, Congress has the right to determine the uniform rules of naturalization. And so Congress can pass a law that just declares people to be citizens. They've done it before. Sometimes they do it for particular individuals, although that's rare. But it does happen, incidentally, by the way, just so long as we're here to learn something legally that might be interesting to you. Most bills Congress pass are what's called a general bill, right? They affect people in general. They apply to basically everyone within a certain class. They apply to a class of people, right? Congress normally passes laws that govern, everyone within a certain class, all electrical companies, all, people that make a certain income, whatever, right? It's a thing that's universal. But from time to time, although rarely, Congress passes what's called a special bill. And by special, they mean it's just for you in particular. Right? They pass a bill just for you. You have your own special federal law just for you. It's fun. And one of the things that Congress does, although not exceptionally often, is they do this for individuals to grant them citizenship, which bypasses all immigration rules, right? Because Congress has this normal immigration. They have this whole thing with immigration, naturalization, and the State Department and all that stuff, right? You know it, you love it. But Congress, of course, those are all laws. The Immigration and Naturalization Service is something created by Congress, right? The rules were created by Congress. Like all the immigration law that immigration is applying every day are just laws that Congress passed, right? So Congress can come in and be like, fuck it, Joe Smith over here is now a citizen of the United States, right? Welcome to the front of the line, Joe Smith. Congratulations, you are now a citizen. And INS is all over here, but what about us? And Congress is like, fuck you, because Congress controls it. So they can do that. They do it from time to time. It's relatively rare. That's not the only reason they pass special bills. They do it for other reasons, but sometimes it would take an act of Congress. Sometimes they will pass an act of Congress just for you because they like you. So sometimes you can get your own special bill. It's nice. Ha ha ha. Right? Special law just for you. And also, of course, they can do it the other way around, although it didn't come to culmination ultimately, but they did it for TikTok the other way around. Remember the TikTok bill? Remember the fuck you TikTok bill? I think it was entitled the Fuck You TikTok Act of 2023. Not really, but close, right? It's like TikTok, you in particular, fuck you. And the Supreme Court upheld it. Remember that? And then, the administration decided not to go with the fuck you TikTok thing, but it was legal. They could have said fuck you. So sometimes it goes the other way too. Congress has a lot of power when they choose to wield it. Okay, anyways, by contrast, statements relating to citizenship of children born to transitory visitors were plainly not essential to Wong Kim Ark's holding. The opinion cited few, if any, judicial authorities, aside from a pre-1789 British common law, where statements about temporary visitors were not themselves dicta within the source cited. And then it rejected the statement as best was obit or dictum because not essential. Extending Wong Kim to decide citizenship of children of illegal visitors or illegal aliens and temporary visitors, which I suppose are legal aliens, therefore resides on dicta within dicta. Nice. Accordingly, statements in Wong Kim Ark suggest a broader application. Yeah, this is just the petition for cert. This is not the merits decision. But they're going to talk about the merits somewhat in the petition. Because, why is this case important? So they're going to talk about the merits. But yeah, a lot of this petition is like reasons you should grant the case. But they still devoted like 11 pages to the merits because, you would. Because you want to get the ball rolling. You want to get the ball rolling in your favor. And you need to explain to them why it's important. So there will be a merits brief in which they will explain this more thoroughly, I would imagine. But it's plenty thorough enough for me. I mean, I'm sure they'll have other things to say about it. They'll just expand. There's been some great law reviews written, probably quote more from that. Try to find other scholars. It'll just flush it out more, I would think. But yeah, so there'll be more in the future. Okay, most notably, accordingly, Wong Kim Ark suggests a broader application of this decision and everyone born are not central to reasoning, and to the extent they imply transient visitors and unlawful aliens are entitled to birthright citizenship, they're not persuasive. Fair enough. Most notably, Wong Kim Ark recited statements from pre-founding source errors that reflected Great Britain's uniquely broad policy of birthright citizenship, which is a little off place because the 14th Amendment was obviously passed well beyond the time that, it wasn't passed along with the regular Constitution. One of the reasons that's because it's called the 14th Amendment, right? So it wasn't passed until 100 years after we were an independent country. So, the English common law is going to be less relevant because, not irrelevant, but less relevant. Yeah, you bet your ass we're going to cover oral arguments on this. You bet your ass we're going to cover oral arguments. I might go there in person. That'd be hilarious. I could do it because I'm a member of the Supreme Court bar. So my odds of me actually getting a seat I might actually go. Yeah, maybe I'll do a Washington, D.C. trip. It's been a while since I've been to D.C. But one of the benefits of being a member of the Supreme Court bar, as I am, is the Supreme Court bar gets seats reserved for it. Now, there's not that many seats, so I'm still going to have to show up probably at dark 30. So I get a seat because it's a very small courtroom. But I might go down there. It's been a while since I've been in the Supreme Court. Washington, D.C. trip, everybody. Yeah, I'll go down there in person and bring like a selfie stick and I'll bring a lavender mic and maybe do some interviews outside. Yeah, it could be fun. So yeah, we might be doing a DC trip in March. I wonder if I can stay at Rob's house again. Or someone else's house out there. Yeah. Can you be? I'm not allowed a +1. Yeah, there are no +1s. Sorry, but yeah, I get to if I show up at dark 30, because I'm sure it will be a popular one even for members of the Supreme Court bar. So if I show up early enough, I can get a reserved seat, which is cool. So kick ass. It'd be helpful if I lost weight, though, because those chairs are, I don't want the chair to break. More fundamentally, the assumption overlooks the Constitution was framed in large part to reject the British theory of king's sovereignty over his subjects and replace the social contract understanding government and citizenship premised on mutual consent. I don't know about that. I mean, we just reinterpreted sovereignty. Yeah, it's like in the British system and the system of many other countries, and Saudi Arabia today, the king is an absolute monarch. It's like, well, the sovereignty is this guy. I guess that makes it simple. What is sovereignty? That guy over there is the sovereignty. Oh, okay. That makes it simple. We had to be all complicated about it and like divide it vertically and horizontally in a whole bunch of ways. So we still have a sovereign. It's just, complicated. Moreover, the broader interpretation of Wong Kim Ark places it at odds with this court's contemporaneous decisions on the same topic, the rights of Chinese immigrants, which repeatedly focused on the immigrants' domicile. Before Wong Kim Ark, the court had held in Law U Bu. I don't believe I've ever heard that decision before. And we've got one called Fong Yu Ting. How am I missing these? I mean, there are, to be fair, a lot of Supreme Court decisions I have not read or understood. Thank you, by the way, for the subscribe. I believe that was a Twitch subscribe. Thank you for that. I do appreciate it. But how am I not getting these names? I don't remember these names. I guess they're decisions that pass my understanding. Yeah. In Law U Bu, the Supreme Court held that Chinese merchants domiciled in the United States were exempt from the requirement to obtain a certificate of entry, which, makes sense because their green card, we don't have that concept yet, but same idea. In Fong Yu Ting, it held that those domiciled in Chinese residents could invoke America's protection against other nations. And after Wong Kim Ark, the court continued to treat domiciled Chinese residents differently and described and applied Wong Kim Ark as addressing domiciled permanent residents. Indeed, this court recognized that Wong Kim Ark concerned children born to foreign subjects only when they were permanently domiciled in the United States. This is very, very well written. Whoever wrote this is writing this very well. I mean, they definitely are getting someone who's at the top of their game to write this. And I respect it. Like this is past my capacity to write it. I know my own limitations. I respect my own limitations. I mean, this is better than I can write. And I mean, I would get a lot of the same ideas, but this writing is better than mine. And it's okay to admit your own limitations. Then again, the person who's been doing this has probably just been doing it a lot longer, and written a lot more briefs. So there's that. They have more experience. So fair. In 1910, a Department of Justice report explained it has never held, and it's very doubtful whether ever held, the mere act of birth on American soil to parents who were accidentally or temporarily in the United States operate to invest such child with all the rights of U.S. citizenship. The Department of Justice said that in 1910? Nice. The same report goes on, the decision Wong Kim Ark goes no further than addressing children of foreigners domiciled in the United States, and Wong Kim Ark did not address the status of children whose parents were accidentally or temporarily in the United States. What do they mean by accidentally, by the way, in this sense? Are illegal immigrants here accidentally here within the meaning of law? Is there what is the word? Okay, I can't believe we're doing this, but what does the word accidentally actually mean? Is that a legal term? Hold on. Okay, I need a OED. I need a big boy dictionary. Let's go to OED and see. Okay. Okay, I can't go to OED. I have to subscribe to OED in order to get OED. That sucks. Okay, I'll just do dictionary.com. Accidentally. Okay. All right. First of all, we've got some ads for some barbells. So apparently the cookies know that I've been exercising at the gym more. We got ourselves a trap bar. We got ourselves an easy bar, then another easy bar, and then just a deadlift bar from Rogue. The bars apparently ship for free. That's nice to know. Okay. Anyways, and we got some benches. Exciting. Damn, I've got a lot of ads.
Taking a family road trip is good.
Shut up.
Taking a family road trip is good.
I don't care about the family road trip. By chance or mistake, in a way not planned or intended, in a non-essential or subsidiary way. Okay. And that apparently is all the definitions. Okay, I don't know if either of those is helpful to what we're trying to describe, but thank you. And why do I not have ad block? That's a good question. What browser am I in right now? I'm in Chrome. Hold on. Let me just put on uBlock or whatever they're doing these days. uBlock Origin. Okay. Get uBlock Origin. This extension is no longer available. Okay. uBlock Origin Lite. What is the latest and greatest? Okay, we'll try uBlock Origin Lite. All right, great. Let's see if that helps with future ads. Damn. Back to this. The gym, by the way, continues to go well. I'm in the deload week right now. That's exciting. My plans for my January 13th, mock meet date continue to go unabated. I'm very excited about that. I'm hyped. I started doing assisted pull-ups and I want to die. I've been doing lat pull downs, and now I'm doing assisted pull-ups, but I'm pulling more weight because, well, they're assisted, but still I'm pulling more weight than I was before, right? Because I was doing lat pull downs at like 180 pounds, and now I'm doing pull-ups at 220 or 230 pounds, and I want to die. Pull-ups are hard. I want to continue doing them, but they're now the hardest exercise in my routine. The pull-up is now the hardest exercise in my routine. I want to die. That is all. Finally, responding resident to Wong Kim Ark would render the clause incoherent. Wong Kim Ark itself recognizes 4 exceptions to rule of citizenship by birth in the United States. That means the routine's working. Yeah, that's one of the things it means. Yeah. The children of ambassadors, of foreign invaders, of Indians, and passengers on foreign public ships. But interpreting jurisdiction to mean regulatory jurisdiction cannot account for those exceptions. Indians, for instance, are fully subject to U.S. law. Indeed, Congress possesses plenary power over Indian affairs. By contrast, if subject to jurisdiction, therefore, reflects the concept of political jurisdiction and direct and immediate allegiance, then these exceptions make sense. Yeah, okay, so that brief makes a lot of sense. Let's read the response for a while and see why they think it doesn't make sense. Okay, we have our brief in opposition to cert submitted by the ACLU. Nice. NAACP. How's the NAACP get into this? Well, I guess in so much as you might think that it's racially based, the 14th Amendment is intended to only speak to Black people. So so maybe that's why they're here, because they want to actually argue against that proposition. So they want the, yeah, that makes sense, I guess. Okay, fair enough. I retract my snark. Okay, petitioners failed to grapple with the statutory claim. Okay, we'll read the statutory claim. You know, if there's a if there's a claim in statute, I'm here for it. So let's see what the statutory claim says. I bought myself some odor eaters for my shoes and some bamboo bags that are filled with charcoal for my gym bag, and both smell much better. Those were both very good purchases. So just recommended. I bought myself some lifting straps, and now I'm trying to decide whether I need to buy myself some Versa grips too. Probably would help with some of these exercises. Yeah. Okay, anyways. Executive order, Court of Appeals, blah, blah, blah. Right, reasons for denying it. Okay. Petitioners frame their petition as a question of constitutional interpretation. They sure do. But the Court of Appeals offered an extensive statutory analysis explaining why 1401 provides an independent basis to enjoin the order. Okay, fair enough. If there's a statute that grants citizenship to more people, then that would presumably control, right? Because the 14th Amendment just creates citizenship automatically to some class of people, but it doesn't prevent Congress from granting citizenship to other people, which they do all the time through naturalization, for example, right? The 14th Amendment says people, born here are citizens, and we can make other people citizens too. So if Congress has a statute that adds to the Constitution, should be okay. So let's see what the statute says. Statutory holding poses a critical obstacle for the case. Petitioner's explicit goal in issuing the orders to undermine the pervasive understanding of the constitutional birthright citizenship, but that doesn't make sense. If you're going to talk about the statute, don't go back to the Constitution. Just talk about the statute. They seek to rewrite Kim Ark. Okay. Collapse the statutory question, but the effort fails right out of the gate because they misapply the governing rules. They agree the language of 1401 is drawn from the 14th Amendment, so it brings old soil with it. But they claim without citation that the meaning of the words enacted in 1940 depend on how the clause was understood in 1868. Well, you actually don't necessarily need a precedent for that proposition, right? It could mean something different. It could absolutely mean something different. But when you use the same words, there is generally a presumption that they mean the same thing. Now, to be fair, you're talking about provisions that were enacted in what? When was the 14th Amendment adopted? 1868? I think. Something like that. So you're talking about something written in 1868 versus 1940. You're talking about something that was separated by 70 years. So, it could mean something different, but it could also mean the same thing if you're using the same language, particularly if they cited to it in any way. 1868? Okay, 1868. Okay, I got the right year. Fair enough. That is not how the court interprets statute. As the court recently reiterated, implying the old soil rule, courts must look to prevailing understanding of how they were used when they codify them. Fair enough. Thus, the court assesses the state of the relevant body of law at the time of borrowing. Okay, this is a court just application of the principle. Statutory interpretation terms must be given the meaning when they have when the text is adopted. Yeah, I have no problem with this, right? If you adopt a statute at one time versus another time, they might mean something different because the language has changed and also the understanding of what is included or not. Right? So if you repealed the First Amendment and repassed it, would it mean the same thing? I don't know. There's a debate, right? It's like, does literally the same words mean the same thing? Or does it mean something different? Fair. It's a fair question. So I'll give them that much. United States versus Kaminsky, for example, this court recognized the phrase involuntary servitude was clearly borrowed from the 13th Amendment. As here, Congress intended the phrase to have the same meaning in the statute as it did in the provision. Whoa, sorry. Accidentally scrolled too much. Okay. Understanding of the 13th Amendment. In 1940, the prevailing understanding of citizenship clause was the same understanding the petitioners acknowledge is pervasive today. Wong Kim Ark, this court authoritatively and precisely, okay, blah, blah, blah. Statute uses words and phrases all received authoritative construction by jurisdiction. They understood according to the instruction, but what authoritative? The interpret is backed in the statute, but even if that's true, Wong Kim Ark didn't speak to this issue. So even if that doesn't work, interpretation so the statutory text persists notwithstanding a potential revision. Kaminsky court looked to understanding 13th Amendment time statute enacted. Possible interpretation will be irrelevant as being statute. Okay. Petitioner of court contests that Wong Kim Ark dooms it. That's not. Yeah, I don't like that. I don't like that argument. It doesn't really work. It's like they're trying to argue that Congress, when it passed the citizenship laws of the 1940s, had Wong Kim Ark in mind. I mean, okay, but Wong Kim Ark doesn't get you there. So I don't know. You're not really doing anything for me. Petitioners suggest generations of judges, lawyers, and government officials misunderstood Wong Kim Ark. It's certainly how anyone involved in 19 started the meaning of it. Okay. Indeed, petitioners acknowledged in the first half of the 20th century the executive branch, which drafted the birthright citizenship, understood the citizenship clause to confer U.S. citizenship even upon children unlawfully or temporarily present aliens. Okay, that's not nothing. For example, decades of administrative practice reflected the widespread understanding with circumstances of birth. Fair enough. Consistent with this long-standing practice, the executive branch committee that drafted the provision specifically advised Congress its fact of birth within territory and jurisdiction, not the domicile of parents, which determines nationality. Congressional debates reflects the same understanding. Okay, fair enough. So they want to try to say that the statute had different understanding using some of the same ideas that they were trying to do for the underlying constitutional provision. So they're trying to say, well, even if you interpret the Constitution that way based on its original understanding, the statute means something different based on what those people understood it to mean. So this again goes to like history. So maybe there's an idea there. You know, there's an idea there. I don't think the authority is as deep or wide so far, but same, okay, you could try the same trick. Congress passed a private bill precedent on the same shared understanding. Private bills don't really get you very far. The bill directed Secretary Label to provide lawful resident status to 2 non-citizens and 2 foreign born. Yeah, that doesn't work. You can't use the private bill, right? That doesn't make sense. The private bill's entire point is to grant status to people that otherwise wouldn't have it. So Congress is like, okay, these 2 particular people in particular, we'd like to bypass the normal rules and give them another status. Yeah, you can do that. Congress can create the uniform rules of naturalization, which also means they can create exceptions on a piecemeal basis if they're so inclined. And they do. They still do it today. Not often, but it's been known to happen from time to time. So yeah, you can get a bill that just declares you in particular to be a citizen. It sometimes happens. Yeah. Or permanent resident or whatever. We can just bypass the normal rules and just, grant you status. We can do that. So that doesn't really get you far. Congress passed a law that specifically graded status in these 2 particular people. Doesn't get you anywhere. And the provisions of 1940 reinforce the same understanding. The Act, for example, provides that when non-citizens naturalize, their citizens born outside the United States are likewise naturalized. Okay. Provide no analogous mechanism for automatic naturalization of children born to non-citizens inside the United States. Okay. Congress could not have intended for children of naturalizing citizens born within the United States to be treated worse than children of naturalizing citizens born abroad. Well, they didn't necessarily have to because those people already had citizenship from Wong Kim Ark, remember? So Congress didn't need to extend them status because they already had it. So Congress is like, okay, we're going to create an extension of status for people born outside the United States. Yeah, Congress didn't mention the people born inside the United States because that had already been taken care of by Wong Kim Ark. They could have mentioned it, but they didn't. So, fair. Congress subsequently rectified the text of whatever as part of the Nationality Act and specifically reinforced the same understanding. This is very conclusory. They're just saying it's true. They're just saying it reflects the same understanding. They're not saying why. Today, numerous federal statutes are based on the assumption, blah, blah, blah. Providing derivative asylum status to children who accompany or follow join a principal applicant, but admitting those born of the United States after applicant's arrival. Okay. I mean, yeah, but if they're granted asylum status, right? If they're granted asylum status, that's a status. And so children born to people who have asylum status, they can be citizens because being granted asylum is being granted domicile. Right? I mean, domicile, as we discussed, is a somewhat difficult concept to pin down very clearly. But what it essentially means is it's your permanent home. It's the place to which you intend to return, even after very long absences. It's your ultimate place of refuge, if you like. And you can only have one of them, right? You can only have one. As far as U.S. law is concerned. Okay? And so if you're granted asylum, what does that mean? It means you get to stay here. So that's domicile. We grant you domicile by asylum status. So now you basically have a green card-like status. Because, well, what is a green card? What is it actually called? It's called lawful permanent resident. Right? It's not really called a green card. It's called lawful permanent resident. That's what it's called. What is an asylum? What is a person who has asylum? A person who has permanent residence. So their children have citizenship by operation of Wong Kim Ark. So, yeah, I mean, that makes total sense to me. I don't see the problem. In response, petitioners point to a single commentary suggesting otherwise in a treatise. But that single line advanced by author without support is thin stuff. Ordinarily, one would expect the government's petition to address these issues. The government's been well aware of these problems as they're developed in depth below, and the plaintiff and amicus briefing oral argument. But petitioners here have done none of that. They dedicate less than 2 pages of the petition to the statute, attempting to collapse the statutory and constitutional questions, despite the fact the 14th Amendment and statute were framed 70 years apart, during which time they decided Wong Kim Ark. But their whole point is that Wong Kim Ark doesn't control the situation. So they're not ignoring Wong Kim Ark. They're discussing it quite extensively. In short, petitioners have not met the case that they can succeed on a statutory issue. And they cannot do so, the court cannot reverse the injunction, even if it somehow reached a startling conclusion. It erred on the constitutional issue of Wong Kim Ark, which it doesn't have to decide that at all, or that Wong Kim Ark should now be read to accommodate the position, which, yeah, that being so, the court should deny. The denial on this basis is particularly appropriate because the government has a clear path forward. It could take the issue to the administration and Congress. And then it said it answered the question of Wong Kim Ark, but it doesn't. Strict citizenship, children born foreign national, respect the electoral and unique constitutional status of Native American tribes. Yeah, blah, blah, blah. Evoke Civil Rights Act to suggest statutory text, not subject to foreign power, should be read in narrow the scope of citizenship, but rejected narrow gloss, more, yeah, blah, blah, blah. Yeah. Should assert that English common law is beside the point because the Constitution is framed to reject it. Okay. Yeah, well, we'll get more into the merits on this issue when we do the merits briefing. But yeah, this doesn't really do much for me. Yeah, we'll do another summary when we do the merits briefing and give it another shot. But I'm not feeling this argument a lot. I'm not feeling this argument, but we'll give it another shot when we get to the merits briefing, which should be pretty soon. So we'll do another stream on the merits briefing when that's released, presumably in a couple weeks. So that'll be fun. All right. Let me take a couple questions, if there are any at this point. Is an asylum a temporary status? It can be. Depends on the nature of the asylum, but there are rules, as you would imagine. Everything's complicated. Are they trying to say the 1940s decision? What was this question? It was a good question. Someone asked if they're trying to use the 1940 statute to reinterpret the Constitution. No, that's not what they're trying to do. They're trying to say the 1940 statute grants status that the Constitution does not necessarily grant. They're trying to say that even if you're right under the constitutional provisions, the statute goes further than the Constitution, which it can, because Congress can grant citizenship beyond what the 14th Amendment grants. The 14th Amendment says these people are citizens. It doesn't say only those people. So what they're trying to say is that the 1940 statute goes further than the 14th Amendment, even if it's using similar or the same words, because the words were understood differently 70 years later, which, to be fair, maybe they were. That's what they're trying to say. Any other questions I can answer before we end the stream? I do appreciate the 151 of you who are here. Are they trying to argue that seeking asylum is the same for granting domicile seeking naturalization? They're trying to argue that the court said that. They're trying to argue the court said that. That children of asylum seekers are equivalent to children of green card holders for the purposes of citizenship. That's what they're trying to say. The Supreme Court already said. So, maybe. I don't know the case well enough, but that could be true. Asylum, after all, is a kind of status. So the degree to which it can be thought of as comparable to a green card is, it could be thought of as equivalent or at least close enough for the same sort of outcome. So that's what they're trying to say the court has already said. So, I buy that from first principles. It could be true. And they're going to argue that all non-citizens are seeking asylum. Well, to some degree, they've already been trying to do that. And the question isn't seeking asylum. The question is granted asylum. Right? Again, it's the same thing as being granted status. So it's like, I want to be a citizen of the United States. I want to be a permanent resident of the United States. I want to have asylum in the United States. The sovereign has to agree. That's the thing. So it isn't seeking asylum. It's being granted asylum, which comes with rules. Do I think the court will decide the case against Trump based on this being executive order, not law? Well, no, because the executive order, to the degree it's valid or not, would only be... The executive order can't do anything other than order the executive to faithfully apply the law. So the executive order is not law. It has the force of law, which is, the executive order is ordering the administration, is ordering himself in some degree to do something that the statute already allows him to do. The statute, the executive order, doesn't have any authority unto itself. So it's only valid in so much as the underlying statute and constitution agrees with his power to do so. So yeah, this is not going to be decided on the basis of the executive order, because the executive order isn't the thing that's in dispute. It's going to be decided on the basis to which the executive order is compliant with the statute and or constitution as the case may require. Considering you have to apply for a green card if you're granted asylum, which means it isn't inherently temporary, even if the need for asylum effectively doesn't end. Yeah, I'm not going to quibble with you on this issue. This has already been apparently decided by the Supreme Court. The Supreme Court has already apparently decided this issue, and according to their brief at least, and apparently according to them, at least for some people in asylum, I don't know necessarily all, but apparently in some people for asylum, the Supreme Court has already decided that that counts as the children of those people get citizenship. So beyond that, I don't have anything to tell you. I'm simply describing what they described to me. You know, I'm simply telling you that that's what they said. They said that at least for some people granted asylum, the Supreme Court has already decided that the children of those people get citizenship. It's like, okay, how does that make sense? And I'm like, okay, well, how does that make sense? Well, green card is lawful permanent resident. Asylum might be also equivalent enough. So the Supreme Court decided close enough to be in the same category. And that's it. That's all there is to it. So like beyond that, I'm just describing. I'm just trying to describe how it makes sense from a logical point of view. And that's presumably how you get there. So that's it. The executive order is ordering action in compliance with other laws. It should be valid. Correct. Yeah, an executive order is simply the president telling the executive branch to enforce a law in a particular way, right? So the easiest example would be something like, let's suppose there's a law that says national parks shall have operating hours. Okay, this is the law. National parks shall have operating hours. And the president says, okay, here's an executive order. We think that parks should be open from sunrise to sunset. Those are the operating hours. Or, an hour after sunrise to an hour before sunset. Maybe that's because we want to make sure people get out while sun is still shining. So an hour after sunrise to an hour after sunset, before sunset. Those are the operating hours. And so the statute said you shall have operating hours and didn't say what they were. And the president's like, okay, by operating hours, I think an hour after sunrise to an hour before sunset. And then a different president's like, I disagree. I think people should be allowed to camp. So they can stay whenever. But, that would be an example. He's just ordering them to do something the statute allows. And, that's a silly example, but the easiest one I can come up with. So the validity of the order is the degree to which the statute allows the president to have that discretion to do that thing. That's the answer. Executive orders are temporary? Sure. Executive orders are temporary. It's true. But the executive order can only be, right, but this goes both ways. The executive order has to be legal. So if Trump's executive order is legal, it doesn't necessarily mean that a different president can do something different, because that may not be legal, right? If the Constitution and the statute means that people who are not born here, that people who are born here of illegal immigrants, if what it means is people born of illegal immigrants don't have status, the president can't change that by executive order, because neither the Constitution nor the statute would give him authority to do so, right? So if President Trump is right, another president can't reverse that because the statute wouldn't allow for it. Now, Congress could reverse it by passing an act. Congress could reverse it, but the president couldn't by executive order. So if Trump is right, the executive order may not be repealable, because the future president wouldn't have authority to repeal it because the statute doesn't allow for it. All right. Well, I guess I'm going to go ahead and sign off for now. This has been a fun discussion. I hope you've had fun with this discussion too. And we will definitely be covering this more as it develops. We will definitely be covering, the merits briefs, which I assume will get more into these issues. So I look forward to discussing that in greater depth. Probably like break them down and do one brief a day or something, so we can discuss in greater depth. But yeah, because it's such a big issue, we'll probably do like a video on like each brief or something. Could be fun. All right. So I'm going to go ahead and sign off for now. I hope all is well. Till later, my friends. Cheers and goodbye.